Oh, well, this isn't part of the event, but I guess we'll continue. Anyway, so I want to introduce our panel for tonight. If you could each introduce yourselves individually, I'm going to hand over the mic.
Hello. My name is Jeremy Sodergren. I am a fourth-year journalism major, and I am the editor-in-chief of our student-run newspaper, The Oracle.
Hi, my name's Olivia. I'm a fourth-year journalism major as well, and I'm part of WFMP. I run a podcast for the honors program. Yeah.
Hi, everyone. My name is Andrew Henneberry. I'm the Vice President of Academic Affairs and Governance in Student Association. I'm also the President of the United Nations Association on campus.
My name is Laura. I'm a senior. I'm a psych major, and I'm an RA, and I also partake in a lot of other organizations on campus.
Terrific. Hi, my name is Nadine Strossen. I'm so honored to be I don't even know how to describe myself. I was going to say the speaker, but that's not accurate because at my request, I am going to be engaged in conversation with all of these wonderful students and with this distinguished lawyer who represents the Student Association. So I guess I'll say I am a discussant here tonight to discuss the very important themes that were raised in the film. I think the most important thing for you to know about me is I have written extensively about free speech, including a book that was published last year, Free Speech, What Everyone Needs to Know. Thank you so much, Andy. Yes, and it's in friendly question and answer format. I was for many years the national president of the American Civil Liberties Union. I continue to be on its advisory board and on the boards of many organizations that work for human rights and free speech. And if I can put on my, and for many years I taught constitutional law, including free speech. For the last few years, I've just been speaking full-time on campuses around the country and around the world. But let me put on my free speech and professorial hat to explain that the kind of expression that is manifest by the poster behind me is, in my view, completely protected free speech because it is non-disruptive and it's conveying a message. We're not imposing any kind of viewpoint discriminatory restrictions, so other people would be free to put up other posters that have other messages as long as it's done in a non-discriminatory manner. But you're the official advisor to this group, council, so I'll ask you for a second opinion after you introduce yourself.
Good evening. My name is Andy Kossover. I know some of you. My wife Vicki and I are your attorneys. We are retained by the Student Association, your student government, to offer services. I put a bunch of our business cards on the back table there, so on your way out, grab one, put our contact information in your phones because you never know when you might need us. I thank Ben for putting this program together, and we're honored to have a distinguished legal scholar like Nadine here to advise us on free speech. Thank you. We got our first question. And then you're all welcome afterwards to ask questions as well. And there's a mic in the aisle if you want. So people who are streaming or recording this will be able to hear you better. Thank you.
All right, so I'm just going to jump right in. My question is, how does this documentary relate to past protests on college campuses?
Okay. Thank you so much, Laura. I love this documentary because to me it brings out a theme that I think is, if not very well known now, and even among those of us who were alive at the time, forgotten. And that is the very, very tight connection between the civil rights movement, the movement to enfranchise black voters in the South, and the student free speech movement. I think a lot of people heard of the free speech movement but didn't realize that the specific speech that students wanted to engage in, that they were not allowed to engage in, was advocacy of civil rights, opposing Jim Crow, trying to help black people in the South realize in reality their constitutional right to vote, which had existed for many years in theory, but was ignored in reality. And the reason why I think that relates so much to today's protests and to today's students' concerns, Laura, is that in my experience, many students feel that have said that they have to choose between racial justice and gender justice and other forms of social justice on the one hand and free speech on the other hand. And as this film shows, nothing could be further from the truth. Without a robust free speech that extends to speech that other people consider to be controversial. I mean, the civil rights movement was controversial at the time. It's really hard for us to believe that. But in today's context, I can tell you there are many government officials who are seeking to suppress Black Lives Matter advocacy, saying, you know, that's hate speech against white people or hate speech against police officers. So especially those people who are advocating for any kind of reform, who are engaging in any kind of protest, including for human rights, you simply can't do it without free speech. And one of the ways that was signified in the film that I thought was so interesting was the student who said, you know, this has united every student group on campus, from students for Goldwater. Those of you who are students of history will know he was the conservative Republican presidential candidate, sort of like the Donald Trump of his time, to the young socialists, that all of them, despite all of their political differences, united around the importance of free speech. And I think, I am convinced that remains true today. Whatever your views are on any issue, including Israel-Palestine, you depend on free speech because your views are going to be unpopular in some quarters, and you can't depend on elected government officials to protect them. That's why you need the Bill of Rights and the First Amendment in particular.
So my question is do you think SUNY New Paltz needs a free speech designated area on campus, and why that might be an issue that we even have that in the first place?
Yeah, I basically think the whole campus should be a free speech zone. And in fairness, there are obviously places on campus such as classrooms and laboratories and gymnasiums that are set aside for specific purposes consistent with the overall educational mission. And so all of you are active in student organizations. I assume you have office facilities for those organizations, and those would not be free speech zones for anybody to come in and talk about anything. But many areas of campus are. Certainly any open space outside, any open plaza, maybe the student union. Basically, any place that is conducive to the exchange of ideas and the communication of ideas about issues that do not undermine the educational mission of the university. And some schools, forgive me, I don't know what your school's policies are, but some schools have adopted what they call free speech zones, designated free speech zones that have been very small, very remote areas of campus. And every single time that type of limited free speech zone has been challenged under the First Amendment, which is many times, it has been struck down as unconstitutional. So far be it for me to spur up litigation, but if you have that kind of situation on your campus, you have a strong basis for negotiating for it to end. And a number of state legislatures have actually adopted laws that prohibit the designation of remote and small areas as free speech zones, saying it has to be a larger percentage of the campus. And by the way, you can only ask follow-up questions if you'd like. Yeah. Yeah, Jeremy, I thought I saw your eyebrow going up.
I guess so. I'm sorry, in that just kind of lost my question. I'll pass it back over here.
It was kind of like a follow-up. So our campus and their policies when it comes to free speech, I think there's this idea and sense of time, place, manner. They kind of talked about it in the documentary. And a lot of campuses have these regulations, but there is a side of that argument that time, place, manner isn't free speech, that's restricted. So I guess I wanted to hear your take on this time, place, manner idea.
Oh, thank you so much. That's a pretty wonky First Amendment question, and this phrase has become quite familiar, I think, for those who followed the contested congressional testimony by embattled former university presidents. And so let me start by telling you, before I get to the TPM rule, that what the Supreme Court has called the bedrock principle underlying the First Amendment free speech guarantee, I already alluded to it, is viewpoint neutrality or content neutrality. Government, including public universities, may never restrict or punish speech solely because of disagreement with or dislike of the viewpoint, the content, the message, the idea. That's why I said I'm assuming we have, viewpoint neutral access for people to post up whatever they want. In contrast, a viewpoint neutral or content neutral time, place, and manner restriction may be enforced if, number one, it is reasonable, and if, number two, it leaves open ample alternative channels for conveying your message. And often those other two caveats are not included. So it is not true that any regulation of where, when, and how you communicate is going to be constitutional. And that may well have been your follow-up question as well, Jeremy, because after all, creating a free speech zone is a content, viewpoint neutral, time, place, and manner regulation. But it is not reasonable, and it does not leave ample alternative channels if it is very remote and or very small.
Not necessarily a follow-up question, but I think it's really important that we talk about this here specifically. Last spring, we had an encampment. Police raided it, 133 people arrested. On the quad, administration said, you can't do this here. And they essentially said no. They had tents. They were told to take the tents down by a certain time. From my perspective and my organization's perspective, those tents were taken down before the time that the school had allotted to them. And I guess, where do we kind of go in a world where we have, I'll kind of go back to what the documentary said. It said free speech is an American value. And I guess I want to hear your thoughts about that, because it seems so much that free speech is a kind of, not necessarily conflict, but there's a specific level of like anti-establishment rooted in it to a degree. So how can something be such an American value when the institutions of America seem to be so far against it? There
were many interesting pieces to that question, so I'll try to answer all of them, but bear with me, it's going to be a while. So first of all, I know that the film says that free speech is an American value, and I think that is true as far as it goes, but it doesn't go far enough, because I know that free speech is a universal human value. And throughout history, around the world, every people of every possible identity, of every possible belief system have fought and tragically in many cases died for free speech, and that's still going on. I mean, just this morning I heard stories about protesters, pro-democracy activists in Hong Kong had just been sentenced to 10 years simply for demonstrating in favor of democracy, and they did that knowingly, saying that it was worth the sacrifice. So sometimes we hear people who are trying to disparage free speech and defense of free speech in this country put it down by saying, oh, that's just American exceptionalism, and you differ from the rest of the world. And I can tell you the answer to that is truly no. And in fact, I've been very involved in the international human rights movement and still am. And my friends and colleagues who are human rights activists in other countries around the world, especially repressive and authoritarian countries, tell me they're amazed that progressive activists in the United States seem to not have the same high regard for free speech that they do. And they've posited that perhaps it is that we take it for granted, and maybe even subconsciously we know it's going to be there to bail us out if we do fall on the wrong side of authorities. But the point that you make, Jeremy, that free speech is inherently anti-establishment, I think is exactly right. And so often I'm asked, as the head of the ACLU and as still being very active with the ACLU and civil liberties, well, doesn't the majority have rights? Why are you always defending, free speech for dissidents and equal rights for minority groups? And the answer is, well, it's precisely the minority groups and dissenting individuals who need to rely on the Bill of Rights, because it is our protection against the tyranny of the majority. To quote James Madison, the father of the Constitution, they recognize that for all the benefits and virtues of democracy, it was no better inherently at protecting the rights of unpopular minorities, whether minorities by virtue of identity or minorities by virtue of ideas. And that's why they insisted that the Bill of Rights had to be added to the Constitution, making clear that there are some fundamental rights that may not be taken away by the majority, no matter how despised the minority might be. And our nation was actually born in dissent. When you the Boston Tea Party, so when people talk about expression, well, that's conduct, that's not expression. Expressive conduct, including dumping tea into the harbor, putting up encampments, are a very powerful way to convey a very deeply held message. And I think the last part of your question had to do with encampments and arrests. So first of all, whether encampments can be completely banned, I think is highly debatable. I was invited to do a debate at Yale, which has a very famous political union where they debate various propositions. And the proposition they wanted me to debate was encampments should be banned on campus. And I took the negative perspective, opposing a categorical ban, but defending the university's right to enforce reasonable, content-neutral time, place, and manner regulations that left ample alternative channels. And here, enforcing these kinds of standards is very fact specific. So at Columbia University, where my husband teaches, it's much harder to find a non-disruptive location for an encampment than it is at Cornell University, where they have expressly allowed encampments, not in the most central area of campus, but a very heavily trafficked area of campus, because they have the luxury of enough space that it's not going to disrupt people trying to go to and from class or other educational activities, and it's not going to stop people with other perspectives setting up alternative encampments. And then to the final part of your question about arrest, even assuming that the and I'm saying assuming just because I don't know the facts here, but so I'll assume for the sake of argument that the university did have legal authority to disband the encampment and to arrest students on some charge. Let's assume that there was a legal basis for doing that. I realize there's a question about that. But even if the answer to that question were yes, that doesn't necessarily mean that it is the right thing for the university to do. And there is always discretion in enforcing rules and regulations. Prosecutors have discretion in deciding how to enforce the criminal law. And at an educational institution, above all else, I would think that the major goal should be to use every possible opportunity as an educational opportunity. And I don't think that quickly arresting people and subjecting them to criminal punishment serves a particularly positive educational function.
So follow-up to that is, how do you think the school handled it? There's 7,000 students. It's not a big college at all. Like Jeremy was saying, there was over 100 students arrested. How do you think this now represents the way that our school has tactics basically against protest, or that they have done in the past? How do you think that represents SUNY New Paltz now?
I'm hesitant to generalize because, if the facts are as you say, it would not reflect positively, but there's a long history and presumably other incidents. I brought up one piece of paper with me because I'm reminded of the first time I had the honor of speaking on this campus. And by the way, as a token of respect, I know your school colors are blue and orange, so I'm wearing kind of bluish and kind of orangish. Please note that. That was a deliberate choice. I spoke here in 1998 when there was a very serious free speech controversy where this university really stood very strong and very courageously under the leadership of a president who was put under enormous pressure by the then governor of the state of New York and somebody on the Board of Regents. And faculty members here and students were also very strongly standing up in favor of free speech. I don't know if you know that part of your history. It was a program, there were several areas of controversy, but sort of similar to what is happening today, topics about sexuality and sex and gender were the flashpoints of controversy, as they are again or still. And the Women's Studies Department here ran a conference. This is a page from a book I wrote, which was published in 1995, and then it was republished in 2000. This is the introduction to the new edition in 2000. And it refers, if you don't mind, I'm going to read it, because you ask about the history and the legacy of your school, Laura, and I think, if you are going to make a plea or an argument that the school should do more to live up to its revered free speech tradition, which is what I associate it with, it might be nice to hearken back to this history. It got nationwide attention. So I refer to the crusade by New York Governor George Pataki and some of his appointees to the New York Board of Regents against the faculty and administration of SUNY New Paltz because of the November 1997 Women's Studies Conference and here's the title, and it's a pun. The first word is a pun, pay attention. Revolting behavior, the challenges of women's sexual freedom. So that notion of revolt and protest was very much being celebrated, but also it's a play on words, recognizing that other people, the majority, might consider the sexual behavior to be revolting in the sense of offensive or disgusting, which included workshops on some sexually oriented themes. Governor Pataki denounced the university's president, Roger Bowen, for defending the academics' freedom rights at stake, and Suny trustee Candace DeRussi was one of many vitriolic critics who called for Bowen's resignation. And he ultimately received a very unusual award from the American Association of University Professors for his courage, but he was backed up by many faculty members and students. So that's the legacy that I see that should be lived up to, and I hope that especially those of you who are leaders in student government will do whatever you can moving forward to ensure that that happens. If you need any, I know you've got great legal advice here, but there's and also from Vicki, there's also an organization called FIRE, the Foundation for Individual Rights and Expression, which happily provides counsel to students and faculty members about free speech and has brought many successful challenges to free speech zones and other unjustified limits on free speech.
So speaking about like moving forward, that was the encampment was a devastating time. The response to it was, well, I would say it was excessive use of force and brutality. And afterwards, a lot of students got charged, and then the charges were dropped, and it was just like kind of like a fear intimidation tactic. And like the institution kind of tried to sweep it under the rug. So I guess my question is, how do we move forward as an institution? Is there accountability that needs to be taken? Like, what should be done to evoke that freedom of speech on campus?
I love the question. You know, what should we do? And you actually can do a lot. And I'm speaking from ignorance, and I'm going to pass the microphone to you, Counsel, because you probably have more specific advice based on your deep knowledge here. First of all, you've got to look at what the policies are. I don't know what the policies are. Either the policies do not allow that kind of what you're describing. Again, I have to say, in fairness, I believe in due process and presumption of innocence, so I'm sure there are other perspectives. But based on what you've told me, there is at least a concern that there was unjustified, disproportionately harsh response. So the first question is that authorized under the existing university rules? If not, that's a problem right there. But number two, if the rules do allow for harsh, unjustified, disproportionate punishment, then there is a problem with the rules themselves, and they ought to be re-examined. Do you know what the governing regulations are on these topics on your campus? I don't mean to put you on the spot. Any one of you. Okay, well, okay. So the first thing is to make sure that you have adequate policies that are consistent with free speech norms and that are known to everybody who has the power to enforce them, including campus security, campus officials. What FIRE found, FIRE did a special survey of free speech problems on universities that had encampments, and it found that the universities where there were the worst problems, arrests that seemed to be unjustified and so forth, were universities where either the rules didn't exist at all or they were confusing and unclear and just unknown to people. So it's amazing how much protection you get by formulating and disseminating awareness of what protections exist and what the limits are. But the limits have to be content neutral and they have to be reasonable, and make sure that every member of the campus community is completely trained in and knowledgeable about freedom of speech and encouraged to exercise it in every possible interaction, starting with recruitment materials, starting with orientation materials. I mean, the same kind of seriousness that has been applied to training and information about sexual harassment and DEI values has to be extended to free speech and protest.
I guess I would just add that, you know, the Constitution was not written to be popular. And Suny New Paltz does have a policy about free speech and the right of assembly. And it's hundreds of pages. So what Nadine just said is true. It's like, it's really not workable. Most people here, whether you're an activist or not, or planning some kind of protest or not, aren't going to familiarize themselves with hundreds of pages of rules and regs. But something Nadine said earlier resonates with me, which is even if they had the right, based on paragraph 111, to, you know, take apart that encampment, the question is, should they have, right? There's a lot of these rules and regs that discretion plays a huge role. And those protesters were peacefully demonstrating. And so therefore, you know, it goes back to what Nadine said earlier, which is not only do you have to look at the rules and regs and maybe revise them so they make sense and so that they are in compliance with the Constitution, which they in some parts very well may not be, but you also have to strive to make the campus better by just, you know, educating. And I would say student government people or other organizations on campus meet with SUNY, meet with administrators, meet with the academics, and it is an educational process in addition to asking them to use discretion may be better. Quite frankly, from my talks with law enforcement and other members of the administration, I'm not sure it would be handled the same way, given a second if we experience anything like that again. I think there is some regret on how it was handled. I don't know if they would say that publicly, but that was the sense I got from my investigation of the matter.
It would be such a great educational and activism experience for students to be involved in the process of negotiating and drafting these regulations, just the way it happened at Berkeley. A very empowering experience, and one that would make an enormous contribution to future generations here on your campus.
I just want to add one quick thing. There's a lot of balancing that goes on in my profession, in the law, that affects all of you. You're always balancing your constitutional rights against what harm it may cause to others. And when we talk about time, place, and manner of free speech, and those rules have to be reasonable, the word reasonable is what becomes the grist for litigation. Because one university's thoughts about what's reasonable compared to another could be very far apart. One example of SUNY New Paltz's free speech policies is they do have a designated area. When you go online and read their free speech policies, there's actually a link to a SUNY New Paltz map. And the designated area for free speech is just the space in front of the Student Union building. And I could tell you that Nadine also mentioned FIRE. FIRE came here, that organization, a free speech organization, when I think it was Governor Cuomo at the time was delivering a check, and they blew it up like, you know, for the engineering building or something, and he, like when you win the lottery, you know, and they blow up the check. Well, he was presenting this big check to the president of SUNY New Paltz, and students were protesting tuition hikes at the time to the governor. And they wanted to demonstrate right in front of where the ceremony was to take place, and SUNY police moved the demonstration saying, oh no, you have to go to the free speech area. So as a result, FIRE came to campus and presented, similar to this evening, what your free speech rights are and were back then. And they have a, I guess what you'd call a grading system for all the universities. And because of that event, SUNY New Paltz got their lowest rating when they moved those protesters away from the governor's ceremony. So I want to say one more thing. Think like you have a greater right of privacy, right? The Fourth Amendment is your right to be free from unreasonable search and seizures. You have a greater right of privacy in your homes than you would, say, in your car, right? Makes sense, it's common sense. Well, the same thing for designated area. There's three kinds of public forums recognized by the courts. There's the typical forum, like Nadine mentioned, parks, quads, places like that, which sort of lend themselves to protests and demonstrations and free speech. And then there's the designated forums, which the courts don't look well upon. As Nadine also mentioned, most times when those are challenged, they're stricken, designated area. And New Paltz, as I just mentioned, has that designated area. So that's one thing that should be corrected. And the third, they call non-public forums. And I think Nadine touched on that also, which is that's the classroom, the faculty building, administrative building. You're not supposed to take over these, although it happens and protest happens there. And again, it becomes a part, balancing what harm is it if the students spend one night, like in Berkeley, in the administration building versus calling in police and having students violently dragged out of there. So again, all comes down to discretion. Thank you. And maybe we want to ask, at some point, if any of you want to ask a question, please raise your hands and we'll try to get you involved. Should we do that? Okay.
Hello. Hi. Oh God, I'm too tall. Okay, my question is, my understanding of free speech is that it is protected to a degree where something that is obscene or hateful or discriminatory is not protected by free speech, obviously. And I'm curious on how that's interpreted in different levels, constitutionally or by a SUNY president or even publication and student association. The term of what is hateful and what is discriminatory has been kind of thrown around very politically, much like land defenders stopping Cop City in Atlanta, or indigenous rights activists, or even potentially trans advocates. I think the reasonable kind of interpretation can change politically. What is there a third-party accountability, or is it just understanding who's in power at the moment?
So you should be relieved to learn that there is no hate speech or discriminatory speech exception to the First Amendment. There is an obscenity exception, and everybody gets it wrong. I know I have heard countless politicians and journalists, and many of them have graduated from law school, and they should know better, saying hate speech is not free speech. Yes, it is, except in certain circumstances. So let me clarify. Remember that cardinal viewpoint neutrality principle, right? Consistent with that, government could never, or a university could never punish speech solely because its message is believed to be hateful or discriminatory. In addition to content and viewpoint neutral time, place, and manner restrictions, which can be applied to hate speech as well as to other speech, right? There is another kind of viewpoint neutral, content neutral restrictions that can apply very context specific, not based only on the content of the speech. And that's often described as the emergency principle. When in particular facts and circumstances, the message either directly causes or imminently threatens certain specific, demonstrable, tangible harm other than hurt feelings. And I don't mean to diminish the importance of hurt feelings, but if we allowed hurt feelings or, being deeply insulted or wounded, I don't mean to underestimate that harm. there's no end in sight because we're upset by everything. Somebody's upset by everything every politician says, right? But if, for example, the Supreme Court has recognized several subcategories of speech that satisfy the emergency exception, and let me mention a few that apply to much hateful speech. One is a so-called true threat, and we lawyers put the word true in front of threat to distinguish it from the looser way we use the word threat in everyday speech. You know, I feel threatened by the fact that I just spoke at Vanderbilt, and students there felt threatened by the fact that Ben Shapiro was going to be speaking after me. That's not enough to justify suppressing Ben Shapiro. But a true threat is when the speaker directly targets a particular individual or small group of individuals and intends to instill a reasonable fear that you are going to be subject to attack. And the speaker doesn't have to intend to actually carry out the attack, but because the harm is already done to your free speech and your privacy and your freedom of movement, if you reasonably, objectively fear that you're going to be subject to harm. So this, you know, the distinction between the two, it can be illustrated by one of the common phrases in campus demonstrations about which the university professors were asked, "From the river to the sea, Palestine shall be free." A lot of people say, well, is that hate speech or is it not? Is it anti-Semitic or is it not? It doesn't matter. It doesn't matter because it can never be punished solely because of objection to its viewpoint or its message. So even if you perceive it as being anti-Semitic, or even if you perceive it as being advocacy of genocide, that alone does not justify punishing it. If, however, you know, let's say a identified Jewish student or a student, you know, who is from Israel wearing an Israeli flag or something is targeted by chanters and, you know, at a menacingly close distance, they chant that, obviously with the intent of instilling some fear that he or she is going to be subject to attack, that becomes a punishable true threat. So I think the First Amendment law is very sensible, no matter what the viewpoint is, no matter how it be, whether it's interpreted as a hateful message or a loving message, doesn't matter. Government can't punish it unless in the particular circumstances it threatens or directly causes certain harm. Let me give you one other example of a specific type of harm that satisfies the emergency principle. January 6th, intentional incitement of imminent violent or lawless conduct that's likely to happen imminently. So you are free to advocate genocide as much as you want, or to advocate storming the Capitol as much as you want. But if it crosses the line to intentional incitement that is likely to imminently be acted upon, that becomes unprotected. Now, you raised obscenity, so I have to be a little bit wonkish. Obscenity is a doctrine that the Supreme Court has not revisited since 1973. It has been thoroughly repudiated by every expert, by many Supreme Court justices. But it's very significant because it is the only category of unprotected speech that is defined solely by its viewpoint or its content, making it completely subjective. And the most famous so-called definition of obscenity, I'm sure you've all heard, came from a Supreme Court justice. People think he was joking. He was being totally serious. He said, "I cannot define it, but I know it when I see it," which underscores exactly your point about this is inherently subjective. How can we entrust to government officials to pick and choose what I like and what I don't like? I know this is hate speech. I know this is obscenity. I know this is extremist speech. That's not a justification for punishing it, except with this soul-lingering anachronistic obscenity exception that is not very much enforced. So it doesn't do that much actual damage, but it bothers me because it's out of sync. It's completely antithetical to the whole philosophy of freedom of speech.
The other aspect I want to ask is how is, I think if I remember correctly, the title is how is like the Oracle or Student Association kind of manages understanding what, like, the viewpoint neutrality a little bit, or like what systems or how does that kind of play into it?
So yeah, from the Oracle's perspective, we are the students' newspaper. So we're here to give everyone a voice. If we were to get something submitted to us that we were felt, like you were saying, subjectively obscene, that we weren't particularly comfortable publishing, that would be a discussion that our editorial board would have. Right. And we would say, is this something that we should publish? Is this something, I can't really give an example. We haven't really had, at least while I've been the editor-in-chief, a situation where that's been the case. Pretty much everything that we get, we'll be happy to publish. We haven't really experienced anything where we've needed to like litigate and decide something in that front.
Gotcha.
I will speak briefly on like student association. Student association, we represent students, especially activity fee paying students, and that also encompasses organizations. Anytime something that like there's discussions, there's always never where we play a neutrality card because we don't represent a group, we represent all. And I think that's really important, and it's enshrined in our association's constitution. So that's just anything that might come up. There's always discussions. We have lawyers. We talk to our lawyers if there's anything. But we never try to limit anyone or limit speech or events. We just try to support students in the best ways we see fit and possible. That also means representing students towards administration and making sure your voices are heard to administration as well.
I think to your point, you kind of said it at the end of your question, is it kind of just up to knowing the powers that be at the time? And I think, unfortunately, it kind of is. What my decisions as editor-in-chief of the Oracle might not be the same, values that the editor-in-chief 5 years from now has. And I do see that as a bit of an unfortunate thing. I think that there should be some kind of, universal process there.
I agree.
Cool. Thank you. Yeah, it was helpful.
Anyone else?
Okay, so I'm going to say a little bit, but I promise it will wrap into a question. First, I want to reiterate what it says on the banner for those who are sitting in the back and maybe on WebEx, I can't see it. It says, Israel became a state by murdering Palestinians and stealing their land.
This is a content neutral, viewpoint neutral, time, place, and manner regulation. Your comment/question has to be germane to our topic of free speech.
Yes.
So can you tell me what the question is going to be, and then you can give the predicate for it?
Okay, my question is going to be relating to how to navigate interactions with policies and policymakers who are in positions of power, who have the ability to penalize us when they're the ones that we're challenging. First, I would like to state that I truly appreciate your presence here. That being said, I don't believe that our president, President Wheeler, I don't think he embodies the sentiment of expressing, allowing everybody to express their free speech. And that in mind, allow me to continue. There is a Kenyan proverb that states, a man who uses force is afraid of reasoning. What does this mean in the context of free speech? Those who police language are afraid of language. People like to feel comfortable and get mad when they are made to feel uncomfortable. Words are very powerful because they have the ability to affect people's minds. When people in power are confronted with words that don't match their perceived realities, a reality they intend to uphold, whether knowingly fabricated or not, they will attempt to criminalize those who challenge them in order to delegitimize their words in any way they can. Terrorist supporting, troublemaking, anti-Semitic, they are scared. They are afraid of reason. They are afraid of being wrong. Or rather, they are afraid of not being able to perform as though they are right. We are here to shed light on settler colonial projects being imposed upon Palestine and Lebanon. Please allow me to finish. I'm almost done.
Okay, really, I understand your question, and I'm not sure you want me to comment on the free speech point.
I would like you to answer my question of how do we navigate interactions with policymakers who have the ability to hurt us, penalize us.
So first of all, I want to completely echo what you said about the power of words. And I think the reason that people do want to censor them or restrict them is exactly as you suggest, because of the force and the influence that words have. This is a really important point that should not be taken for granted, because often those of us who strongly defend free speech, including the entire United States Supreme Court, those justices strongly disagree and are splintered on many other issues, but they are essentially unanimous in strongly protecting freedom, even for the most controversial speech that substantial numbers of the general public want to censor. I think that's a very interesting dichotomy, and it's one of the reasons why I wrote my book, a sort of a primer about free speech, because what distinguishes Supreme Court justices from the rest of the public is that they know the law. They know what the law actually is. They know the history that gave rise to it and what the situation actually was when government had more power to restrict speech, something that many people today advocate without recognizing the dire consequences. So those of us who support free speech are often accused of denying that speech can do harm. That is exactly the opposite of the truth, as you said very well, and as the Supreme Court itself has said. We support freedom of speech, not despite the fact that speech has power to do harm, but precisely because of that fact. It is a power that can do a great deal of good as well as a great deal of harm, and that the greater harm is empowering government or university officials with greater discretion that will inevitably be used disproportionately against whatever views they disagree with. So again, I'm completely agnostic as to the facts here, but if there has been, first of all, of just a violation of neutral rules. So if you are relegated to an overly small or remote free speech zone, or if you have to comply with onerous regulations on encampments or on posting, that can be challenged in and of itself as not being a reasonable content neutral time, place, and manner regulation. In addition, if there is viewpoint discrimination going on, that's a very serious First Amendment issue. So if you can show that there's a double standard, that some expressions by some students or of some perspectives are restricted, subject to greater restrictions than expression by other students or other perspectives, that would violate the viewpoint neutrality principle. You're on a public campus, so the First Amendment does apply. And don't take that for granted. Many people don't know that if you're on a private campus, the First Amendment doesn't apply, and there are far fewer free speech rights. But in a case way back in the 60s, coming from our student activism era, the Supreme Court essentially said that you have the same free speech rights on campus that you have in the general public. That is, when you're not in a classroom or a laboratory or a facility that's specifically dedicated to the educational process.
Hi, I'm a first semester freshman on campus, and every conversation I've had relating to the encampment that happened, everybody has treated it as very hush-hush, we're not supposed to speak about it. But as somebody who believes in free speech so heavily, I'm wondering why all our students believe it's okay to treat such a huge situation as hush-hush. So my question for you is, how should our students move forward on this situation, especially to advocate to younger students that we won't allow larger institutions to limit our speech?
When you say it's treated as hush hush, is that because the administration is sending signals or faculty are sending signals that you shouldn't talk, or is that students are fearful of talking because they're afraid of peer pressure?
I would say I've gotten hush-hush from not only professors, but as well as people part of the student government and the student association, and from several other organizations. I've known quite a few people who, even I see as friends, who have been afraid to speak about it and who have actually felt they have been traumatized by the events that occurred that day, as well as suffering financial losses due to the way things were handled.
So two answers, because you've given two different sources of the problem of people not speaking. If it is any official action by the university or by anybody who is cloaked with university authority, such as an individual administrator or member of the staff or faculty, that is subject to First Amendment constraints. And I've laid out the basic free speech parameters here. However, if the suppression is due to not wanting to offend or be perceived as saying something that's offensive or unpopular or is going to lead to peer pressure, shaming and shunning and ostracizing, canceling, these are all terms that we've heard, there is no First Amendment remedy for that, because all of us do have a free speech right to engage in very harsh criticism of views that we disagree with, including disproportionately harsh criticism. And I don't know the situation on this campus, but let me tell you from exhaustive surveys that have been done by many organizations, including FIRE and Campus Pulse and Heterodox Academy and the Pew Research, shows that on campuses across this country, students and faculty members are engaging in massive self-censorship. Topic number one, on which they say we cannot have a free and frank and candid discussion on this campus about this topic. Topic number one is Israel-Palestine recently. But other such topics are abortion, police, immigration, crime, anything to do with race, sex, or gender. And then you drill down and say, well, why can't you have and by the way, the answer, we can't have a candid conversation or we engage in self-censorship, occurs not only in class, but also in public areas like the student union or cafeteria, dormitories. It's not only in conversations with faculty members, but it's in conversations with your peers, with other students or faculty members with other faculty members. And 99.99% say the reason is not we're afraid that, the police are going to be called in, not that we're afraid that the president of the university or a faculty member is going to discipline us. We are afraid of other students. Faculty members say that. They're afraid of students who, drill up a social media storm of protest. Now, I said people have the right to engage in unfair criticism and harsh criticism, and they have the right to advocate that somebody should be shunned. But for those of us who wish that campus would have a free speech culture rather than a campus culture, we urge you to please show some restraint, to please show some forgiveness and some compassion. Please show some open-mindedness and willingness to listen and not just immediately condemn somebody as an evil person that you don't want to have anything to do with because they say something that you might disagree with, or worse yet, say something that is unwittingly perceived to be ignorant or offensive. And we've gotten to be such a harsh and judgmental society in too many contexts, and I think that's especially unfitting with the special role of a university where we should feel most comfortable. Yes, we can engage in criticism, but that the criticism is part of an ongoing conversation. Now, too often, the criticism is a way to end any conversation or any interaction at all.
So I just wanted to talk from like a student association standpoint. And granted, I don't want to speak for everyone in student association, but we do have this general idea that, not idea, but principle that we do represent all students. And from a personal, like standpoint, May 2nd was really hard. It was very emotional. I was there, and it was a really hard time. But coming into this role, being on student association, we talk about this thing of called shared governance of, I have to sit across from all these administrators who, inflicted a lot of pain on a lot of people I love and care about. I don't want to get emotional, but, there's a point where, I can't just sit here and yell at them and show them my grievances. I have to be able to look forward and find a future. And a big part of that is representing students the best way I can do possible. So I do want to say Student Association has done a few things that I just want to reiterate just to show that we do care. And I'm sorry if it didn't come off as strong. But, I was in Senate last year, and we passed a resolution at our emergency summit following May 2nd, a day of protest that should be held every year on May 2nd. Days change. I don't really know the full extent of it. We're getting in planning. But we passed a day of protest because we don't want people to forget about what happened, because I think that's a huge part of our history now. We passed a statement last year after the events. We canceled Springfest because we didn't want students to even be near police following what happened. And this year, and now I sit on the executive board, and I've seen firsthand that we sit in these meetings, we try to represent students the best we can, and we make sure administrators do not forget what happened last semester. And I do apologize if that didn't come off as strong enough. And I actually really appreciate you saying that, because it kind of gives me motivation to do more. So thank you.
Thank you. I just have one more quick question. So a little bit ago, there was an email sent out to all students about hate speech being graffitied on College Hall, I believe. And while I know graffiti is against the laws of everywhere, the idea that it was hate speech, I feel, is questionable. There were quite a few rumors about what was written on the wall, and one of the ones that I found most common was the death toll of Gaza. So my question is that allowed to be deemed as hate speech and punished as hate speech, or should it just be punished under the idea of vandalism and not including the idea that that is clarified as hate speech?
If you were paying attention, you would know the answer. I'm saying that with a big smile, right? In answer to the question from the person standing behind you in line, sorry, I don't know your name, I explained that there is no hate speech exception to the First Amendment. So it is incorrect to say that anything can be punished, whether it's hate speech or not. I mean, that's not a legal concept. It is in the eye of the beholder. And you're giving an example where obviously somebody looked at it and thought that it was hateful, but that is not a justification for censoring it. But regardless of what the message said, even if it said, I love the president of the university, that's still graffiti, and it should still be punishable, reasonably, hopefully in an educationally constructive manner, as vandalism.
Thank you. It was just the fact that it was broadcasted to all students as hate speech, so I just felt like it impeded on what students would be allowed to say.
It's a really good point, because it shows, and I don't mean to single out whoever the official was who issued, subscribed to that description. The ignorance on this point is rampant. Most people do think that there is a hate speech exception to free speech, but it's too bad that leaders of educational institutions are propagating disinformation, but they in turn have gotten it from other government officials. So I think, the kinds of questions that we're going over here, I think are so important, really show how helpful it would be, as we talked about earlier, to first of all, educate students in the First Amendment principles, and then to make sure that those principles are reflected and respected in the policies that are enforced on this campus.
Thank you so much.
You're welcome.
Hi, me again. I wanted to mention some really important context that I do think changes the question. For the idea of like why is there not a conversation about it? There is the idea of like cancel culture and just being difficult to like be professional to the people of opposite opinion. But very important, the Title VI has recently been revised over this past summer and has no?
It wasn't revised, but
Okay.
go on.
Then the reason I bring this up because I believe I've seen examples where maybe it's not institutionally written down in like the legalese of it, but the like institutional intimidation of like using hate speech referenced by the president and the UPD captain, those are two people, but also the real conflation that's happening legally and also in conversation that anti-Zionism is anti-Semitism and kind of stifles conversation in that regard. So even if it's not necessarily written down that you're not allowed to say these things and that like obvious restriction of freedom of speech, the power dynamic of an institution saying these things and really like police standing up in arms about hate speech and the graffiti and that kind of thing, I think that does stifle the conversation. And specifically if we know the people that are doing it, UPD captain and the president, that kind of is difficult. There's people, there's face to it. That's
So thank you so much. You remind me that I wanted to make one other point in response to this question from the first year freshman, and that is that not only is it factually and legally incorrect. I'm sorry, I'm describing you since you didn't tell me your name. I have the identifying characteristics you did share. Not only is it factually and legally incorrect, but it might actually be a free speech problem in and of itself, because and again, I'm completely agnostic about the facts. I haven't done my own fact checking. I'm depending on what you're telling me. But assuming that that's an accurate account, that can be seen as a university official saying, we view this message to be hate speech, and that can well have a speech suppressive impact reasonably on students thinking they're not going to express that message themselves because they will be on the wrong side of the perspective of these university officials. And let me again give you an important but helpful First Amendment law point. The First Amendment says Congress shall make no law abridging the freedom of speech. And by the way, the word Congress has been interpreted without dissent to apply to any government official and any level or branch of government, including state university officials. So state university officials shall make no law. Make no law has also been interpreted very broadly without dissent as any official action, right? It doesn't have to be passing a law like a statute. Abridging the freedom of speech, abridging has also been interpreted, again, without dissent, very flexibly. I mean, this is constitutional language, so they're broad concepts intended to be interpreted broadly. Abridging goes beyond, laws that say thou shalt not, or direct punishments or prior restraints are familiar examples. But the Supreme Court has sensibly said, without dissent, we're going to interpret this in a functional, practical way. If, as a practical matter, what the official is doing tends to suppress speech by people or by particular people or by particular perspectives, that constitutes an abridgment. So if a reasonable person would be deterred or chilled from expressing that message, even in a non-graffiti context, right? You might still think, well, because they've said not only is this graffiti, but it's hate speech, that may well deter people from expressing that message or similar messages. And that would violate the First Amendment. Now I've forgotten what your exact follow-up question was again. Okay. Okay, you raised something else that was important, but maybe you can get back. I'm sorry. Oh, yes, that's very important. I know there are people standing in line, but if you don't mind, this is a really, really important topic. So Title VI is title or a section or chapter of the famous 1964 Civil Rights Act. Most people are more familiar with Title VII, which prohibits employment discrimination on the basis of race, religion, gender, and so forth. Title VI prohibits any institution, private as well as public, that receives government money, federal government money, from engaging in discrimination or tolerating discrimination. So it applies to every single educational institution with very few exceptions. They all get government money. It certainly applies here at a state university. And the types of discrimination that are prohibited include anti-Semitic, anti-Israel, anti-Palestinian, anti-Muslim, and so forth. But contrary to what the questioner surmised, Title VI has not been revised or amended. But something did happen that I assume you're referring to. In May, the Title VI is enforced at an administrative level by the Department of Education, Office of Civil Rights. So if somebody makes a complaint that a university that's receiving federal funding is engaging in discrimination against Jews or against Muslims, the investigation is done by the Office of Civil Rights, Department of Education. So given that there have been so many controversies and charges and countercharges, sometimes this very same campus is accused of anti-Semitic discrimination and anti-Israeli discrimination, but also Islamophobic and anti-Palestinian and so forth. The OCR, abbreviation for Office for Civil Rights, issued like a multi-page guidance in which they tried to explain to universities, here are examples of factual situations that would trigger an investigation for potentially violating Title VI. Extremely importantly, that guidance reiterated what has been the position from the beginning and in the law itself. No statute can make an exception to the constitutional freedom of speech right. A constitution, we have a supremacy clause in the Constitution, which says the Constitution is supreme over every other kind of law. If a statute, including a civil rights statute, is inconsistent with the First Amendment as part of the Constitution, the statute is unconstitutional. And so the OCR reiterated that students and other members of the campus community may never be punished for engaging in protected expression. And it doesn't matter whether it's anti-Zionist or anti-Semitic or, pro-genocide or anything else. You can't punish it based on dislike of its content. Now, where it gets, I think, confusing to people is that the concept of discrimination under Title VI extends to what's called hostile environment discrimination or hostile environment harassment. And the Supreme Court has defined that as arising, you have to look at all the facts and circumstances. These are always very fact-intensive, fact-specific determinations. If there is taking into account all conduct, including expressive conduct, that there is a pervasive atmosphere. That the environment is objectively offensive. That means not subjectively, but that a reasonable person would find it offensive and discriminatory. And it is so severe and pervasive that it effectively deprives certain members of the campus community of an equal educational opportunity. It's a hard standard to satisfy appropriately because the penalty is very severe, loss of federal funding. And the OCR said that students engaging or other people engaging in expressive conduct, demonstrations that are voicing messages that members of the campus community find objectionable and offensive can be taken into account in determining whether there is hostile environment. But the response by the university can never be to punish the speakers. But the university has to do something. And the something would include providing support and counseling, psychological services to the students who feel intimidated by the expression. So that may be where the confusion lies. And there's a lot of confusion about this.
We're going to get to all your questions. I just wanted to ask Nadine a variation on this theme, which is probably of interest to many of you, which is if a student, I guess, participates in controversial speech, whether it's perceived as anti-Semitic or it's pro-Nazi or anything like that, should employers have the right to refuse jobs or revoke previous job offers, as we saw happen to several law students?
So with apologies to the people who are in the line, this is a very important question that may also be exercising a speech suppressive impact on students. I'm a lawyer, so I have followed this in the legal community. I quite frankly have not followed what, if anything, other employers beyond the legal community are doing. But as Andy said, there were some well-publicized incidents shortly after October 7th of last year, where the first one that I heard of was an NYU student leader, some leader, and maybe the head of the student government at NYU Law School, who made a pro-Palestinian statement and publicly had their job offer. It was more than an offer. It was a contract, right? Not to be wonky about it, but it was a contract, right, of employment withdrawn by a prestigious New York law firm. And after that, we've had federal judges saying they wouldn't hire students, even some federal judges who are saying they wouldn't hire students from any student from Yale Law School or Stanford Law School, not over this issue, but over other student protests. And the law firm that I worked for before I became a faculty member has publicly announced that it is looking into the social media posts and engaging in investigations of any protest activities that applicants for jobs there are had engaged in. And I find this very troubling. I don't know if I told you this, Andy, but Time Magazine actually commissioned me last year when this issue first developed to write a piece about it, which I did with a co-author who's a cognitive neuroscientist, because I think this has to do with brain development issues as well. The Supreme Court has struck down, even though the Supreme Court has rejected constitutional challenges to the death penalty in general, it has struck down as cruel and unusual punishment death penalty for juveniles and other harsh penalties for young people. Now, admittedly, law students are above the age of majority, but brain science shows, I'm sorry to say this, that there are portions of your brain that are not yet fully developed. And, you know, that to me is just frosting on the cake to my generally permissive, educative attitude. If you want to try to engage with people on their ideas, you don't do it by punishing them. And so I, in the spirit of saying, I wish that we would all exercise our free speech rights in a way that is more tolerant and more forgiving and more open to dialogue, I wish that employers would exercise what is, in almost all cases, their legal right not to hire somebody because of disagreement with their political views. There are a few, so there are, as you well know, it is illegal under civil rights laws to refuse to hire somebody or to fire them, as happened in the NYU case, based on race, religion, gender. But the federal civil rights statute does not protect you against discrimination based on your political views or your, philosophical views or your expression about those views. There are a few state laws that do outlaw, arguably, that kind of discrimination, but that's the rare situation. So basically we're saying not only, first of all, employers have no legal obligation to not discriminate on those bases. Secondly, they have a First Amendment interest of their own, freedom of association and choosing whom not to associate with as well as whom to associate with on any basis they want, including ideas, and that has to be weighed in the hopper. They have a responsibility to their clients. If they think their clients are going to be alienated by a certain employee, it's fair and reasonable for them to take that into account. But against all of that, I end up urging them to please err on the side of forgiveness, second chance, presumption of innocence, not this disproportionately harsh overreaction. I'm sorry, it's a complicated answer, but it's a very complicated question involving, it's not one of the, it can't be answered binary, yes or no. Not that any of these questions can.
Yeah, sure thing. So I'm going to try to organize my question as best as possible here. So I'll start with a short preface, but so free speech oftentimes can be paraded around as a sort of cure for all ills, to the neglect of, shall we say, more concrete or more material concerns. Oftentimes this issue can be used to shunt sort of more emergent problems and sort of waylay them in discourse that frankly none of us get paid to engage in, as opposed to, for example, administrative officials. Do you understand what I'm getting at here? And so in the spirit of my comrade's question here, when all the how to put it, when all the discretion, I suppose, is sort of working against you, right? Because we know, practically speaking, or a lot of us here know, practically speaking, where free speech ends, and it's when the dogs and the cops come out, right? I don't know. This is sort of a perverse question, and I'm not trying to be hostile, but how does one justify situating a dialogue like this around free speech given the present context, right? Because we know, practically speaking, and I'm saying we intentionally, I mean we know that our free speech is certainly not protected. I could give some examples if it would help you, but we know that certain classes are protected among others, and I'll wrap this up here. But so do you understand the thrust of my question here?
I think I do, but so let me try to answer it, and please feel free to follow up if I'm not doing justice to your question. First of all, those of us who strongly defend free speech don't do it as a speaking for myself, I'm not a philosopher. I'm an activist and an advocate and an educator, and I advocate and educate on free speech precisely because of its concrete, practical, instrumental value, as well as its intrinsic value to each of us as individuals in exploring and expressing our own identity. But I am fully committed to the whole range of human rights, the ACLU's mandate and mission of defending all fundamental freedoms for all people. I still completely adhere to that. And I do not spend so much time talking about free speech because I privilege it above other rights that are completely dear to me. But because I see free speech as being the essential prerequisite for advancing every other right. And you're rolling your eyes because you say free speech has failed you, but it's not free speech that has failed you. It is the failure to respect and enforce free speech that has failed you. And that's why I am constantly advocating and educating, because ultimately the movements for justice in this country that triumphed first were subject to not only dogs, but fire hoses and worse, lynchings. Even we saw students being killed for trying to, help people actualize their right to vote. That's a failure of free speech. It's a failure of equality law. And to me, so the way that the civil rights movement, the abolition movement, all the other movements have succeeded as far as they have, and I say that recognizing that, the struggle is still going on, but enormous progress has been made exactly at the point when people were able to voice their messages without being punished, when other people heard their message and engaged with them in a constructive way. And you and others are using the power of protest, I think, extremely effectively, including, tragically, I wouldn't wish this, but including when your free speech rights are not being respected. I live right around the corner from Columbia University, where my husband is a professor for that reason, among others. But Columbia has received worldwide attention. I think the encampment started in reaction to the president's testimony of throwing free speech and academic freedom under the bus. And then after the disproportionately quick and harsh law enforcement response there, what happened? Encampments not only came back at Columbia, but spread all over the country, including here and indeed in other countries as well. So the fact that there was suppression and violation of free speech rights was not the end of the story. That re-galvanized further protest, and in a more constructive vein has led many campuses to do what I hope happens here, if it hasn't happened yet, which is to revisit and revise and improve the policies and procedures on campus to make sure that these rights exist not just as some airy-fairy abstraction, but as something that will give voice to those who have unpopular positions. I'm saying unpopular with, I assume, with the administration, from what I'm hearing.
Okay, I suppose it's. I'm trying to. Yeah. This is a complicated thing. So, cultural hegemony. This is what's on my mind. So, the president of our university, I think we all received this email. Sort of sent out some kind of a bizarre mass email, sort of reminding everybody we have a bias reporting system here, sort of explicitly labeling, targeting a particular group of students. Sort of encouraging people, that if any sort of talk about, genocide or something like this, encouraging people in their classrooms, which, if I understood you talking about this initially, is one of those spaces where free speech is perhaps sort of struggles to get out one's mouth a little bit more. So this sort of these sorts of very legal, but these sorts of enforceable judicial mechanisms, right? Not, someone's going to bully somebody else, right? Or nothing quite so this, but somebody's going to use a mechanism designed to protect free speech. These are the sorts of things that, politically speaking, are intensely problematic and are intensely hard for, at least for me, I'm sure everyone can see me struggling up here, intensely hard to talk about within the context of free speech. So my question isn't exactly legal, it's more discursive and it's more cultural. How do we preserve the political content of our speech without allowing it to be sort of just whitewashed into some, do you understand?
I think I partly understand, and again, you're welcome to follow up if I don't get it completely. And please don't apologize about not legalistic, because the law is only part of it. As I've emphasized, to have free, so let me say it another way, an idea that I've tried to convey before. Having legal protection for free speech is necessary, but not sufficient to have meaningful free speech. We also need a culture of free speech where we feel comfortable expressing ourselves. And even, universities that have fantastic policies on paper still can have terrible actual climates and actual experiences where students just fear expressing themselves for various reasons. Now, let me say something about bias reporting teams, and I'm not sure if this is what you were getting at. And again, you know, the devil is in the details, and they vary from one campus to another. But on many campuses, they have been successfully challenged as violating freedom of speech because students understandably and reasonably are afraid of saying something that might trigger somebody to file a report, which then triggers an investigation. And universities say, oh, but it's non-punitive. And the answer is, again, this goes back to that sensible First Amendment principle. If, as a practical matter, somebody is going to be deterred, it doesn't matter that you're saying it's non-punitive. It's a deterrent to comfortably expressing your perspective. You don't want to be the subject of one of these reports. You don't want to have to be dragged into some administrative office to defend your idea. And we have, the U.S. Supreme Court hasn't yet ruled on it, but the level of courts right below the U.S. Supreme Court have struck down this whole apparatus on many campuses as because of its deterrent effect to free speech. The other point that you raised that I want to address is in classrooms, what I meant to say was it's not when you're out on the quad, or use the legal term, a traditional public forum, anybody can say anything about any subject, except if it's obscene, right? Or it satisfies the emergency principle. But any perspective goes on any topic. In a classroom, you can be limited to, and should be limited to, only addressing the topic of that class. So, the excellent question that I said, please make sure that it addresses the topic of this forum, which is free speech. I don't want to hear anything about anything else. So that kind of viewpoint neutral restriction can be enforced in class. But it can't be, so you may not say something about sociology in a math class, or you may not say something about a current world controversy in a math class, regardless of what the perspective is, and vice versa.
We're running out of time. I think we have 2 questions. Can we do those? Or? So, Professor Strossen,
I'm happy to talk to you individually afterwards.
be around a little bit, but apparently I don't ignore the irony of this, but we'll have to
It's a
we'll have to cut short some of us.
well, because to allow other people to talk, as agreed, in time, place, and manner. But for those who are standing in line, and even those who aren't, I've got time, and I'll talk to you individually out in the hall. Thank you all very much. I really appreciate your and thank the student panelists. Thank you.
How are you?
Not bad. Don't you think the students did well? You all did well.
I was in a academic and closing a comment, not a question. That was really just a joke for Professor I'm sorry, I wasn't.
We're gonna move down to the atrium area. So those who have any follow-up questions will be down in the atrium. Thank you.